every instance where the Constitution has not specified a system of representation different to what Section 19 requires. You can't even put scales, because if you weigh something against nothing, it will be that thing. So if there is nothing that empowers the IEC to do what it did, then we're even in a worse off position than what Justice Matlanga was dealing with. I'm sorry, I'm looking for the quotation in, yes, Freedom Front. You'll find that at page 14 of our heads to the conviction point. The same thing that Justice Matlanga was saying was expressed by the Electoral Court. It said, quote, "We need to remind ourselves that what we are concerned with is a citizen's right to stand for public office," which was the issue in that case. Not the other right, but we know that they are conjoined. Which right is enshrined in Section 19(3)(b) of the Bill of Rights. It cannot be limited, save as justified in Section 36 of the Constitution. It is therefore against the backdrop of these imperatives that Section 47(1)(e) must be interpreted and applied. It has to be interpreted, I think, in a way that must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom, and gives effect to the right to stand for and, if elected, to hold public office. It cannot be clearer than that. We know from the Hyundai line of cases that that's what this court has held should happen even in the so-called harmonization process. Assuming for a minute there was a conflict between 47(1)(e) and Section 19, or even Section 35, then it has to be resolved in favor of those fundamental rights. So that, I'll come to Justice Matopa's point. Let me try and deal with this systematically. So where does that leave us? It leaves us with the three issues, and I'm surprised Mr. Ngokaitobi says there are 2 issues on appeal, because there are clearly 3 issues when this court has specifically asked us to make special heads of argument on the conviction point. You can't say there are 2 points. The third point is the conviction point, and correctly so, because it's an absurdity to separate the sentence from the conviction when it comes to the question whether Section 47(1)(e), whether those terms are what was contemplated in 47(1)(e). And put terminology aside, Justice Matopa was indirectly criticized for using intention of the legislature. But it doesn't really matter. The point is, when the Electoral Court says, is that within the contemplation of Section 47(1)(3). They exactly mean that. In other words, did the drafters contemplate that they will now be dealing with a conviction, which is not the conviction that they have prescribed in Section 35? Surely that's just myopic logic. How could the drafters have expected or contemplated that now all of a sudden there's a new species of conviction now in Section 47(1)(e), which is totally repugnant to Section 35. When Justice Khampepe, and that's why we say we are not fighting with that judgment, Justice Khampepe in many passages says that, I think it's paragraph 76 or 80, she says, this is not a conventional criminal trial, in so many words. And she says, as was pointed out by Justice Theron, she says, we're dealing with a situation where there is a denial, no less than that, a denial of the right to appeal. And then she says at paragraph 76, which answers the question, Deputy Chief Justice, that you posed in the directions. It's here. She says, ordinary criminal proceedings differ vastly from civil contempt proceedings. I'm reading at page 43 of the papers and 76. And it cannot be that something as simple as a party's, in this case the appellant's pleadings, can have the effect of marrying these two markedly distinct concepts. So the majority says these two concepts are markedly distinct. So that's the answer, that the civil proceedings and the ordinary criminal trials are markedly distinct things. Now, if we accept that, then the Deputy Chief Justice's question or the court's question becomes relevant. If we accept that there are two distinct, then the only question that remains is, does Section 47(1)E apply to both types? And the answer must be a resounding no, because Section 47(1)E surely applies to type 1, let's call it that, which is the criminal proceedings as we all know them, because that's what it says in Section 35. Apart from that, apart from the frank concessions, with respect, the frank admissions that these rights are being infringed or limited or denied, whichever word you choose, there is the following problem that my learned friends have. And it also arises from one of the questions. Where does the court derive the penal power to, sitting as a first instance, impose a criminal sanction? And that's why it has not been understood why we make this concession readily. Mr. Ngukatop spent time trying to tell us that contempt is a criminal offense. We don't quibble with that. We made that concession in the earlier court, but it serves this purpose. If it is a criminal offense indeed, then is the conviction a conviction? That's the secondary question which was raised in the directions. And the answer must be no for the following reasons. Assume it's a criminal offense for present purposes. But it's a misnomer to call it a conviction. Actually, it's just, this thing is not even a conviction, it's a committal. It's a committal order, unsuspended committal order for contempt of court. That's the correct categorization, legal categorization. It's not a conviction, because a conviction we know is defined in Section 35(3). And if it is a committal, unsuspended, on an urgent basis, by the court sitting as a first instance, in motion proceedings, everything you can think of, could it conceivably be what the drafters contemplated? Which drafters would have contemplated that one day, despite what we have said in Section 35, there will be a criminal conviction, which is a result of urgent proceeding in motion court by direct access, denying all, and I'm saying that deliberately, all the 15 rights listed in Section 35(3), all of them. Not only were those rights denied, but they were even used as punishment. Mr. Zuma, one of the so-called aggravating reasons why he had to go to jail directly and so on, was because he exercised his rights to remain silent. Something that benefits all other persons who have criminal conviction. But this court said, because he refused to respond, for example, when we said we want mitigating circumstances or whatever. That denial of the Section 35(3) right is actually the very reason why he must go to jail. We can't have this. We can't, the taking away of the freedom of a person without a trial is not something that can be brushed aside by, terminological tricks. It has to be said that these framers of the Constitution contemplated such a thing. On what basis? Then we move to, so we say that the conviction firstly is a misnomer, it doesn't apply, and it's not a conviction as defined. But then let's go to sentence. Sentence suffers from the same problem, because as we all know, the sentence comes from the conviction. So that's why the two things are not separable, as my learned friend Mr. Ngwatobu would like us to have. And by the way, just for the sake of, yes, thank you. Okay, no, let me, I'm sorry, Justices, something has just been brought to my attention, which is so that we round off the conviction point. One of the points we make is that the court in Faki at paragraph 27 posed a very important question and said that counsel had raised the issue as to whether a conviction for civil contempt would constitute previous convictions. This is important. Remember, forget previous. That's just an adjective. But the question that was posed there was, is a conviction for civil contempt a conviction to such an extent that it would constitute a previous conviction? Yes, I've got it. Yeah. And this is what Justice Cameron said at paragraph 20. Okay, let me paraphrase to save time. He effectively says, I'm leaving that question open. Says that question will be answered in another matter as to whether this conviction, which looks like it at face value in front of all of us, is a conviction in real terms. Now we make 2 points about that. One, it is that if the answer to that question was as obvious as Mr. Ngwatobu would like us to have it, then Justice Cameron would not have left it open. It is because it's not an easy question whether this is a conviction or not. And that's the reason that he left it open. The second question is, second issue is that we say the electoral court then, and then we also give them a defense, maybe because the matter was urgent and so on, lost a golden opportunity to answer that question, which Justice Cameron had posed. By the way, if anyone listens to the transcript of those proceedings, the very first thing Zondi J.A. asked me as I stood up, but Mr. Mpofu, is this a previous conviction and will it appear in this SAP 69? That's the exact question that is in paragraph 27 of Faki. It even talks about the SAP 69. The second issue is that this is not just something where we're clutching at straws just to, because it's convenient to do so because we received a direction from the DCJ. No, this was pleaded. It's pleaded by us. If you go to page 262, at paragraph 24 of the Notice of Appeal, the very first document that was ever served in this matter, Notice of Appeal, we say the following. a declarator, such as the one issued by the court, that's the Constitutional Court, cannot amount to a conviction, a previous conviction, or a criminal record as intended in the section. Now that should close it, because we say that it might look like a conviction to the naked eye, but in terms of the law, it is not a previous conviction. So we were provoking the question that was raised in Faki. Now, so it's not a conviction, it's not a previous conviction, or at the very least, there's no answer to, at best, there's no answer to that question. But that mere fact that that question it might be hanging in the air. Imagine if someone was convicted in the magistrate court or in the high court, and then you came and say, is it a conviction? Everyone would say, what are you talking about? It's obviously a conviction. Will it feature in the previous conviction? Of course. Will it be in the SAP S69? Of course. But this so-called conviction in a civil court and in motion court and so on cannot be. The next point comes to the mischaracterization of section 167 and 172 of the Constitution. Imagine if you could wake up some of the drafters of the Constitution and you say to them, when you drafted 172, 1A, giving you the power to give declarators, in that you included the power to impose criminal sentences as a court of first instance. They would say, sorry, that's not 172. How could you, under 172, 1A, impose a criminal sanction? And that is why you must read 172, 1A. And remember, in paragraph 86 of the Khampepe ADCJ judgment, 86, she says, explaining where the power to grant that sentence, she said, by this point it needs no repeating that the only rationale provided to this court for the granting of a punitive sanction was that put forward by the applicant. However, it is trite that this court enjoys a wide discretionary powers and that we are enjoined by the Constitution to grant appropriate remedies that are just and equitable. In these circumstances, and for the reason that follow, I'm certified that an order of unsuspended committal is just and equitable. And the footnote is footnote 101. Look what it says. Section 172, 1B of the Constitution empowers this court to make any order that is just and equitable. Well, I'm prepared to say that, to lay my life on this one, that no drafter of the Constitution would have contemplated that 172, 1A or B for that matter, empowers this court to give a criminal sanction as a court of first instance in motion proceedings, in urgent proceedings. Never. So the very exercise, that then goes again to the question of the conviction. This is a conviction in terms of 172, 1B by the admission of the majority. Goes back to the original question. Could it have been that the drafters of the 47.1E, when they were drafting that, contemplated that there will be a conviction and a sentence issued in terms of 172, 1B? No. Surely. The next one is section 167, which is also being abused. Section 167 says that the 167.6, national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with the leave of the Constitutional Court, A, to bring a matter directly to the Constitutional Court, B, to appeal directly to the Constitutional Court from any other court. So that's the point. So this court was clearly not exercising, because it said it's denying the right of appeal. So it was clearly not exercising the power under section 167(6)(b), but it was exercising the power under 167(6)(a) to bring a matter directly to the Constitutional Court. How could it be that by giving that procedural right, the drafters of the Constitution wanted to take away the fundamental human rights in Section 35? How could it ever be? How could it be? Because this is a procedural convenience, which A, does not contemplate criminal proceedings, but B, certainly does not contemplate itself defeating the Bill of Rights. It can be. So it's not a conviction for that. Thank you. For that reason as well. Sentence. Now, the sentence we say, we use 35.3.0 as a proxy. Whenever I talk about 35.3.0, you must know that I'm talking about all those rights, because all of them were denied in Section 35.3. But Section 35.3.0 brings the matter home easily. Why? Because Section 35.3.0 says you have a right to an appeal. In other words, that right we know attaches to both the sentence and the conviction. And that right must be exercised. Everything I said earlier about conviction applies to it. But that's not the question, of course. The question, we must always come back to the question in this case. When the framers of the Constitution did 47(1)(e), did they contemplate a sentence such that it breaches, limits, denies 35.3.0 rights? And the answer to that must be a resounding no. And that's what Justice Zondi was saying, that this could not have been in the contemplation of the drafters, that there would one day be what Justice Khampepe called an unprecedented and unimitable situation. You know what that means? That means it has never happened and is unlikely to ever happen again. So it was a particular situation influenced by the fact that Mr. Zuma was a head of state and so on. And there's a whole thing about, there's a whole section on that. So that is why it is in that respect that we say, this is what, if you look at it crudely, this was nothing but reminiscent of the so-called Sobukwe Clause under apartheid. And whether one agrees or doesn't agree with that categorization, the point is only this. Could the framers have contemplated that when they wrote those words, convicted and sentenced in 47(1)(e), it would include some unprecedented, in fact, I'm putting it in milder terms. Sorry. I think it's paragraph 56. No, 56, at page 32, yes. She said, however, I'm alive to the fact that the case before us is so markedly distinct from any matter that has preceded it, that it exceeds the expectations of legal precedent. The result is that, despite my efforts, I have found very little solace in our jurisprudence. In other words, there's nothing like it. The extent and gravity of the contempt in this matter is singularly unprecedented and absolutely inimitable. So I left out those adjectives. Singularly unprecedented and absolutely inimitable. Who can say that the drafters of the Constitution contemplated such a thing? So the sentence is even in a worse position than the conviction, save for the fact that the sentence is in any event a surrogate of the conviction. And that's why we say we really welcomed, without needing to patronize the court, we welcomed the directions from the Deputy Chief Justice on this question of conviction. Because with the greatest respect, it was absurd to say the sentence is not within 47(1)(e), but the conviction is. The section is very clear that those two things go together. 47(1)(e) says, anyone in this section is convicted of an offense and sentenced to more than 12 months imprisonment. And even in the appeal proviso, it says, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined. So it's clear that the two things go together. It would be absurd for any court to hold that the sentence was not a sentence because of Section 35, but the conviction was a conviction. So we welcomed the directions in that sense. But let me just say the following quickly about the right of appeal. And you'll find this at pages of in our submissions on conviction. From page 8, from paragraph 25. This court said, well, in Dali, it says the minimum that it says 3530, the minimum that it envisages and implies is the opportunity for an adequate reappraisal of every case and an informed decision on it. One of the justices, I can't remember, I think it was Justice Matopo, asked this question as to whether the Section 3530, they said the bare minimum it envisaged is a chance for a reappraisal. And then in Stein, the following was said, the right is directed at ensuring that there is a reasonable procedure for correcting errors, coming back to Justice Majid's earlier point this morning, for correcting errors that may have occurred at the trial stage. In a substantial number of criminal cases, convictions result in prison sentences. During its term, imprisonment brings the liberty of the individual to a halt. It also impacts on the individual's dignity. Therefore, it cannot be overemphasized that before this happens, there must be procedural checks and balances of such a nature that wrong convictions and inappropriate sentences are reduced to the barest minimum. An appropriate reassessment mechanism is an important cog in this scheme. I think it was Justice Madlanga who said that. And then in Stein, it was also said that 25(3)(h), which is the equivalent of the current 35, that every accused shall have the right to a fair trial and so on. So this court has specifically said on many occasions that the right in 3530 is an inherent feature of a sentence. It's not some by the way thing. It inheres in the thing called a sentence. So a sentence that is bereft of that right is not a sentence, cannot be a sentence for the purposes of Section 47(1)(e). Even if you were allowed to do the so-called harmonization exercise, that is completely disallowed. Now, so that's the first part of whether the sentence is a sentence for the purposes of 47(1)(3). Then the last point on the merits is the remission point. Now here, you get literally, gymnastics of the first order. They say that they accept, grudgingly I must say, because they didn't accept this for a long time in the electoral court. But they now say, because there's no other way, quite frankly, they accept that Mr. Zuma's sentence was completed on the 11th of August, 2023. Now, if you read that together with the order of the SCA that we discussed earlier, which said he must return to escort for the purposes of serving the remainder. What was that remainder? The 9 months. So, but for the remission, he would have served the 9 months. I don't know if he would be out now. Maybe not. But you can't wish away the remission, because but for the remission, he would have served the 9 months. And that 9 months, justices, is what is the extent to which the sentence was reduced. Smith says so, Busheko says so, all the cases say so. They say that the effect of remission is the reduction of the sentence. And I don't want to disappoint Justice Matopo, but I'm not in a biblical mood today. So forget about the biblical definition of the remission of sins, which, by the way, is the only reason we all go to church on Sunday. If you thought you could go to church and then when you go there, they say, no, but remember 10 years ago, but you said, but that sin was remitted. They said, no. Mr. Ngopaitobi says no. So you must go to hell, literally. No. So let's forget about that for a minute and look at the definitions that are more conventional. Sorry. The definition in, I had this. The definition in the Oxford dictionary, law dictionary, says that remission is the cancellation of a part of the sentence. It's that simple. Can I find it in a way? It's the cancellation of a part of the sentence. Funny enough, the definition that you also find in the Oxford Thesaurus says the following, among other things, that remission amounts to setting aside, lessening, reducing the sentence. Now, if that is so, and those definitions accord with just for Oxford, page, what paragraph? 73. Okay, thank you. I'm sorry, Justices.
We're on extra time that you're not even granted.
Yes, I'm aware.
We don't want to be accused of being unfair by the others who had to abide the clock.
I'm sorry, Justice. I was taking my I know that this is defined in our heads, but the point is that there's also section 82. Let's forget about the Bible for now. Section 82. 1B of the Correctional Services Act is almost a mirror image of that Oxford dictionary.
148.
Okay, thanks. I'm told these are in paragraph 148 of our heads. Yes, at page 50. So